All right, let's get on the record. This is 25 SC 007534. Just stop that. There we go. And that is State versus Clarke. We are here on Tuesday, June 2nd, a day later than scheduled, to start Dr. Clarke's trial. If I could have the appearances for the state.
Good morning, Judge Aaliyah Smith, Board of State. And ADA Davis. Good morning, Judge.
Hello, Ms. Davis. Good to see both of you. And Mr. Hirsch, I think maybe there's some changes in staffing. It's good to see you this morning. Why don't you give me the update for now for Dr. Clarke, and I'm happy to pivot in whatever way we need to pivot.
Thank you, Your Honor. Without giving you, well, I have some requests, but the answer is Mr. Hill, Justin Hill, has been hired by Dr. Clarke and has filed an entry of appearance.
Welcome aboard.
Good morning, Judge.
So based on that, I do have a request. May I make it this time?
Okay.
So prior to today, I've asked for a continuance ad nauseum. The court has been very patient in listening to the various reasons why, most of which, the vast majority of which have been documented either in a motion for continuance or in an email. But my announcement at pretrial, if I just could put a few things on the record, was that I was asking for a continuance. It was denied. My motion at the calendar call on May 28th is that I was asking for a continuance. It was denied. Over the next day, the weekend, and even yesterday, the court still listened to me and entertained the reasons why it should be continued and denied it. But my announcement is not ready for many of the reasons I've articulated. I'm happy. I mean, I think it doesn't matter. Fault doesn't matter. But to the extent fault does, I'm happy to take the fault. I'm happy for this court to hold me in contempt for not being ready. And I've told the court that I would rather that be the outcome than for me to have a client where I thought due process was denied to her. This is a case that she can win. It's a case I think she will win if she has an attorney who's fully prepared. She understandably has lost confidence in me. She's seen me here and say that I'm not ready. I haven't done X, Y, and Z. And basically, I think the message from the court is, well, that's on you, right? Because I didn't get a continuance for cause, so it must be on me. Or that's easily what I think an observer would take from it. So she has one shot at this. Obviously, the criminal trial is extremely important, but her license is on the line as well. So she has counsel that she believes and trusts in, as well she should. Mr. Hill's a fine, fine lawyer, and who can be ready, given a chance to look at the documents. Obviously not today. I can say, I believe I have everything now. Over the weekend, my investigator, Mike Nealon's been working on the case. So in terms of impeachment and collateral facts investigation that I needed to have done, I feel like I have all those leads. Some of them need to be shored up. Some documents still need to be gotten. My answer is I'm not ready here today. Given that Dr. Clarke has done everything that can be expected of her. She hired me. She has civil lawyers. She has a lawyer for her licensing hearing. And I think, suffice it to say, when you have three different lawyers on three different events, and one certainly, the other two have already started, you think all your lawyers, when it's time for the ultimate trial, or first in trial, are ready. So when she saw that I didn't get the continuance on the calendar call date, she had started making arrangements, and she has now retained on her own attorney, Mr. Hill. So obviously I want to let him speak if the court wants to hear from her, if Dr. Clarke wants to speak, if the court or Dr. Clarke wants to be heard, if the court wants to hear from her. But once again, given that she has done everything correctly, given that my announcement's not ready, I feel like that should be my problem, not Dr. Clarke's problem. I would ask you to give Mr. Hill some reasonable time to get ready for the case.
Okay. Thank you for that. Mr. Hill,
Yes, Judge.
what would you like to share?
And good morning, Judge.
Good morning.
Um,
Actually, let me start with a question for you, and then you can add whatever you'd like. When Dr. Clarke reached out to you to discuss hiring you and bringing you on board, did she share with you the pending trial date?
yes, Your Honor, she did.
So when you accepted the contract and entered into it with her, you knew that we had trial either yesterday or today?
She informed me that trial was coming, was scheduled for today.
Okay.
She informed me essentially what Mr. Hirsch just informed this honorable court, that he wasn't ready, that she did not feel comfortable moving forward with trial today. And I would like to say that I have a lot of respect for Mr. Hirsch. A lot of people aren't able to admit when they have dropped the ball. And for him to come up before this honorable court and say that to you, unapologetically, I have a lot of respect for Mr. Hirsch. So I do want to commend him for that. But nevertheless, Your Honor, Ms. Clarke did reach out to me. She informed me that trial was scheduled for today. She does have a constitutional right to attorney of her choosing, and this is her life, Your Honor. This is her life. Ms. Clarke, Dr. Clarke is a professional. This case has implications on her life, I would say, beyond a lot of other individuals that come before this honorable court. This is her license. This is what she's worked hard for. This is her life, Your Honor. So all that being said, I do believe that Dr. Clarke is entitled to effective counsel for this trial. I understand that this honorable court does have discretion in whether or not to grant a continuance for matters in these situations. However, the Court of Appeals does direct this honorable court to balance when determining whether or not to grant a motion to continue. The Court of Appeals does direct this honorable court to balance some essential rights, and those including the right to counsel of her choosing against the need to maintain the highest standards of professional responsibility, the public's confidence in the integrity of the judicial process, and the orderly administration of justice. In this situation, the Court of Appeals has many times held that requests for continuance on the eve of trial for either delay or for reasons such as an accused not agreeing with counsel's trial strategy, those things are not grounds for a motion to continue. But in a situation like this, Your Honor, I do believe that Dr. Clarke's constitutional rights are being implicated here. If she has been informed that the counsel that she has cannot be effective, is not ready, is not prepared to come to trial, I believe that that puts her in a different position from, just a standard, I just want a continuance because I don't like my lawyer, or because, for some delay tactic to try to, to try to strategize in the case. So all of that being said, Your Honor, I do understand that Ms. Clarke did inform me that trial was scheduled for today.
So you came in with eyes wide open?
Your Honor, I did come here with the understanding that that trial was scheduled for today. However, I, as an attorney, I became an attorney to assist people when they are in situations like that. I became a criminal defense attorney to assist people when they are in situations like this. And with Dr. Clarke being a professional, I'm a professional as well. So I understand her, I empathize with her. And I believe it would be counterintuitive to simply just turn Dr. Clarke away because of the position that she was in. I felt it appropriate to come before this honorable court and request a continuance. I do believe that Dr. Clarke deserves competent counsel. effective counsel, and she deserves a fair trial. And I would respectfully ask that this honorable court take all of that into account and grant this continuance. If the honorable court were to make me proceed to trial today, quite frankly, I don't see where anyone would benefit from that. Not Dr. Clarke, not myself, not this honorable court. The justice would not be benefited to force myself to go to trial today. So that being said, I would respectfully ask the honorable court to grant the continuance, allow myself additional time to review all the evidence. We can be first up on the next trial calendar, Your Honor. I'm fine with that. But I would just like some time to go over everything and go over all the implications go over all the options with Dr. Clarke and go over all the implications of how proceeding would be for Dr. Clarke.
When you say all the options, tell me what you mean by that.
Options. So I know that this case does also have implications on her medical license. So going over, coordinating with her attorney with that matter to see what's going on with that. And I know she was just offered a plea yesterday. I'm not sure how that would affect her medical license as well. It may sound good on paper, but if we don't know how she accepts the plea and, next thing you know, she can't practice medicine anymore, I know that would be devastating to Dr. Clarke. And that would also be something that she would not have been able to contemplate when she accepted the plea. I do think that would even go into whether or not that plea was freely and knowingly, into those aspects of accepting the plea. So all that being said, Your Honor, I would respectfully ask the honorable court to grant the continuance.
All right. Thank you, sir. Appreciate it. Ms. Smith?
Can I throw in one tidbit, just for the court's edification? It's not an argument.
Okay, more tidbits.
Yeah, no, for informational purposes, we had an sort of informal status yesterday. Since then, the state has offered a plea last night. And I think that's germane because it's along the lines of something my client might accept or may not, but it's not a definite no, right? It would be a misdemeanor plea if it all worked out. But she has to know before she can evaluate whether to take that or not, how good, all the evidence of trial. And so it's to piggyback a little bit on what Mr. Hill said. I wanted the court to know that there was a plea offer last night for the first time, and thank you for it, of misdemeanors that I think that she should have time to consider. The court was kind in extending her final plea right from April 21st till now. But if this also is a final plea, and for the first time she's offered this and has these collateral consequences, if we were at a final plea, if we were back on April 21st, and this was offered, I said, Judge, I just need a week to go over this with her and to find out collateral consequences and for her to see the strengths and weaknesses of her case. Also, I did receive the medical records yesterday, last night. So
Thank you, Grady.
from Grady.
Yes, thank you, Grady.
Yes, thank you, Grady. Their system is up. So that's another piece of information, again, due to my own timing, but that now she needs to consider because it could be a huge boon to her at trial if the injuries are inconsistent, and now we need someone to look at them.
Okay.
Thank you.
My recollection of our conversation yesterday, you and Ms. Smith and I, was that, in fact, Dr. Clarke had time to speak with, I think it was Attorney Price, name doesn't matter, the lawyer who is Dr. Clarke's lawyer, advising her on issues of licensure. And what I thought you had relayed, Mr. Hirsch, was that lawyer was very reassuring that misdemeanors would not be an issue. The question was, if it's a felony, what's the nature of the felony? So my hearing that the state has reached a place where they're offering misdemeanors consistent with our discussion yesterday, puts everyone in a place that one may be consistent with clearly people were disorderly on the date in question, whether there was an assault or not. And more importantly, long-term, it is a resolution that protects Dr. Clarke's professional licensure. So I don't know what's changed from when you and I and Ms. Smith spoke to now, that now we need a week to consult with Attorney Price to figure out if a misdemeanor plea would have professional implications or not. But that's a switch, and sort of I'm feeling that happening more and more, switch of lawyers, switch of news about this. And so maybe you can clear up that misdemeanor situation.
100%. The court's recollection of what I said about what John Price said is accurate. Dr. Clarke didn't have that conversation with her lawyer. I had the conversation on the phone for about 15 minutes yesterday around 1:30 with the lawyer. But Mr. Hill didn't, Mr. Hill and I haven't been able to talk that much. So that's not something I've communicated to Mr. Hill. So that's why he said it. But the only other point of clarification is that's a conversation I had with her lawyer, not that she had.
Okay.
And in terms of the switch, that was just Mr. Hill thinking, because he and I haven't had a chance.
No, I'm not attributing this to Mr. Hill is new to the project. So I was referring more to what.
Substantively, the court is correct in terms of what my conversation
with Attorney Price was.
Attorney John Price.
Okay, thank you.
One more thing that I would like to add, Your Honor. I also do want to add that Dr. Clarke did make diligent efforts to retain new counsel. She reached out to me Sunday. As far as, so no, she informed me, and if this is incorrect, Mr. Hirsch can definitely clear this up. She informed me that she had a conversation with Mr. Hirsch on Sunday, where she was informed that Mr. Hirsch did not feel as if he didn't feel comfortable moving forward and did not feel as if he could be effective. And I spoke with Dr. Clarke on Sunday. So, and yesterday is when she retained me. So I do just want to put forth to the court on the record that Dr. Clarke did make diligent efforts. She moved swiftly to retain new counsel as well.
Okay, thank you. Ms. Smith.
Yes, Judge. In this case, the state understands that the defendant now has a new counsel. So we would leave it in the court's discretion on if the request to get a continuance is granted or not. In this case, if it is continued, the state will send all discovery that we have to the new attorney on the case. And also, if he has any issues with the sound or anything like that, we'll work with him to troubleshoot those problems. But the state is ready.
Okay.
Oh, and also, Judge, I'm sorry. We did give a new offer in this case, and we will keep that offer open for a reasonable time, depending on how long the continuance is and things like that. But we don't expect for the offer to expire like tomorrow or something.
Okay. Well, the offer needs to stay open this morning. I'm going to order up jurors in a little bit. We can talk more about the case, and I'm going to get a few things on the record about preparedness and whatnot. But it may be that Dr. Clarke and one of her lawyers wants to use this time to speak with Attorney Price about the wisdom and safety of the misdemeanor resolution. But this is a case that is going to go forward. We had a final plea date in April, over a month ago. At that time, I was informed that the defense might need a little time to acquire civil discovery, which is basically paperwork that Ms. Clarke, Dr. Clarke, ought to have anyway, because it is the civil case where she's being sued by the alleged victim in this case, and that the defense wanted to look through that. That's an evolving situation and not a reason to slow down the criminal case. If civil discovery becomes available, then that might be something that could be used in the criminal case. I did preserve Dr. Clarke's final plea rights because it was represented to me that the civil discovery might change the nature of the negotiations between the parties. There was no motion filed about any discovery shortfalls until May 26th, which was 2 days before the call of the calendar. And it's important that the record reflect that really what was listed in the motion for discovery deficiency was not that the state didn't produce things, but that there were technical issues that the defense was encountering with what was produced. And this all boils down to the body cam. The state produced body cam footage now twice. In both instances, there was an audio component. It just was, I guess, not intuitive how one accesses the audio component. But the state has, I find, always been timely with producing the discovery. And I just wasn't brought into it to fix anything. Not that I'm the technical fix, but I certainly could bring the parties together to ensure that if there was any kind of instructions that the state needed to provide the defense to access the audio component of the body cam, they could do that. So again, it was technical issues, not non-production. This question of the Grady records, to me, that's completely different from body cam. The only way a defendant can get body cam footage is through production by the state. But any medical records of treatment that the alleged victim received at Grady are legally equally available, because it just requires a request to me to issue an order, which I did upon request from the defense, and ta-da, the Grady records were produced. Often, the state does obtain them when they want to be able to verify or prove up a victim's allegations about injuries sustained, but the state's not under an obligation to get them. If they do get them, they need to turn them over. In this case, they did not obtain them, but Grady is not a state actor in the discovery sense of law enforcement, GBI, et cetera. So those Grady records were just as equally available as a deposition transcript from the civil case. So I find that the defense could have and should have been ready for today. I also appreciate Mr. Hirsch's candor in saying that for whatever reason, he didn't take the necessary steps to be able to say he's ready. Mr. Hill is in a fundamentally different position. He ought not to say I'm ready. I don't know how he could be coming into the case yesterday. And he is correct that Dr. Clarke has an absolute right to the attorney of her choice if she can afford that attorney. And she has retained Mr. Hill. But that election and exercise of her constitutional right to counsel of choice is a shield. It can protect her if she believes she's bringing on board a lawyer who will more effectively vindicate her rights and defend her in this case. But it is not a shield from the progress of cases, and it's not a means of delaying cases. So I welcome Attorney Hill. He has confirmed on the record he knew full well when he entered into an arrangement with Dr. Clarke that trial was starting today, and that there was the possibility of a continuance. I trust Mr. Hirsch had let Mr. Hill know there hadn't been any so far. And I will tell you that switching lawyers is, in my mind, not the way to force a continuance. In the same way that I'm not forcing you, Mr. Hill, to trial. You came into this case knowing that it could go to trial. And so if you remain Dr. Clarke's lawyer, then you are making the professional election to represent Dr. Clarke as her attorney in this trial. The case is going to move forward, and you're on or you're not on. I'm not forcing you to stay on, but you've elected to join the defense team. I think there will be ample time this morning while we work through jury selection for someone associated with Dr. Clarke, if not Dr. Clarke herself, to engage with Attorney Price to see his thoughts about the advisability of a misdemeanor plea, which, based on what I've heard from both sides, seems like an eminently reasonable resolution of the case. But short of that, this is a calendar that has been published for weeks. This is a case that has been indicted since last year, and we are more than halfway into 2026. And what we hear far too often is cases move too slowly in Fulton County. And it's rich indeed to be told this case is moving too fast. We finally get it right and are moving something according to the kind of scheduling order people ask for again and again and again. And now all of a sudden, that's too fast. But we are going to move forward. I'm going to ask Ms. Nelson to order up the 48 jurors And we'll have the standard pretrial, let's get ready and talk about what jury selection is going to look like. Ms. Smith, anything else you want to get on the record before I go through the checklist I need to go through?
Nothing further. Thank you.
Okay. And I need to know, will I be primarily working through Mr. Hill or Mr. Hirsch? I'm happy to have both of you right there.
I was gonna say, can we have a few minutes, maybe 20 minutes to speak with Dr. Clarke to see how it is that she prefers moving forward?
Sure.
I understand the honorable court ruling and, you know, myself personally, it's not about myself. This isn't about me. This isn't about Ms. Hirsch. This isn't about the honorable court. This is about Dr. Clarke. And I want to have an opportunity to speak with her to see, you know, how she best feels comfortable moving forward.
Okay. Got it.
On the motion to continue, for continuance and what you would the court perfect the record and talk about the list of witnesses as well? Because that was.
Yes, thank you for flagging that. So actually, the defense was first to file a list of witnesses. I mean, technically, the indictment had a list of witnesses. It was just Officer Watson. But the state did file a list of witnesses, I think, on the eve of trial. Missed the 10-day deadline to file the list of witnesses. We did talk about this yesterday in our pretrial conference, Mr. Hirsch, Ms. Smith, and I. And the state's list of witnesses on the surface is lengthy. It has many, many, many police officers. Ms. Smith explained why they're all included. It also includes, unsurprisingly, Ms. Perkins and her daughter. What I came to appreciate from the state's presentation yesterday is that there really aren't any surprises on here. In fact, there are a couple of duplicate names, so it's a little shorter than it looks. But be that as it may, it was late disclosure, but of officers who are identified in police reports or who were the officers whose body cam footage was part of discovery that, again, was originally provided back in January of this year. And so in one respect, it's nothing new, but very much so, Mr. Hirsch, it was a late disclosure. I'm happy to require the state to make available each of the witnesses it intends to call, other than the Perkinses, in advance of their testimony, if defense counsel wants to interact with them. But there aren't any witnesses who are, if you will, coming in from left field of like, wait, who is Officer Deandra Irvin? What's her connection to this case? She's either the author of a report or named in a report as these were the three officers who responded, but Watson wrote the report because he got there first. But it was a late disclosure of a witness list. I am comfortable directing Ms. Smith to share with the defense before they meet with Dr. Clarke which witnesses they intend to call. This was a potentially could call. I think you said yesterday, Ms. Smith, that it likely would be at most 6 or 7 witnesses. I think that included the Perkinses. And again, I don't find them to be surprise witnesses at all. They're named as alleged victims in the indictment. But if you would let Mr. Hill and Mr. Hirsch know before they confer with Dr. Clarke, which of the police officers that you would definitely call, and then like, hey, depending on how this one goes, we might also call that one, or they're on here just in case. You never know how the trial goes, and we wouldn't want to have excluded someone, and then in rebuttal, we need to call Officer Boykin, and we didn't mention her name. Okay?
Yes.
I'm gonna, Mr. Hill, still order up the jurors because it takes a little while. I'm fine having them wait outside. If the Dr. Clarke's decision is to go forward with the trial, we still need to talk about voir dire a little bit. If you're gonna be on board for the case, you and I have not done jury selection before. Mine's a little different than the works in Fulton, and so I wanna just walk through how that goes. So I'll make sure we have time to discuss what we need to outside the presence of the jury, but I'm going to still have Ms. Nelson order them up because there are other judges who want jurors, and that can take a little while. And that way we won't be stuck waiting for jurors. If when you return, the answer is let's get the potential jurors on in here. Okay. And you are welcome to use the jury room to speak in private because I'm not going to clear the courtroom if you all want to have a privileged communication. All right. Let's do it.
Your Honor, before we enter into a plea, I just,
Let's make sure we can get on the record. We're jumping the court reporter here. Are you good getting on the record? Okay, we're back on the record in State versus Clarke. We took a 28-minute-ish break so that Dr. Clarke could confer with Mr. Hirsch and Mr. Hill. I also ordered up the jurors. I believe they're here. I see some human outlines through the window, but they're outside the courtroom, not inside the courtroom. Mr. Hirsch reported to me that the plan for now is to move forward with a non-negotiated misdemeanor plea. Is that correct?
yes, I just need to clarify one thing before we do.
Please.
My understanding is, but I want to be on the record, I want Dr. Clarke to hear it. The state, I believe, will be asking for some custodial time. We'll be asking for straight probation. My understanding is that obviously the court will make a decision and sentence her, but the court will, let's say the court goes with the state or gives her any time, if the sentence varies from what the defense is asking for, she will be able to withdraw her plea.
Almost right. If the sentence is more severe than what you and Mr. Hill advocate for, then yes. But just as a hypothetical, let's say it's 3 misdemeanors and you're recommending 36 months probation. And I hear enough of this and I say, you know what, it's going to be 24 months probation. That's a variance, but it's a favorable variance. And I don't know why on earth Dr. Clarke would say, I don't want that. I wanted 36 months, but I just don't want there to be any surprises. I may vary in any number of directions. If the sentence I impose has more community service than you asked for, if it involves custody and you're not asking for that, then you and your client will have an opportunity to talk about it, come back and say, no, love it, but we'll take it, or no, thank you. And if it's a no, thank you, it's as if it never happened. It's nothing we discuss in front of a jury or anything like that. So it's basically a trial run of what would a misdemeanor non-negotiated plea look like.
Okay, thank
All
you.
right.
We're ready to move forward. And if you'd like to enter into a contest.
All right, Ms. Smith, are you ready to handle that?
Yes, Judge.
Okay. Do you mind, well, I guess if you don't mind coming up to the witness stand so that Dr. Clarke's looking in your direction and she's answering your questions. So Dr. Clarke, I'm going to ask you and whichever attorney, and both attorneys can accompany you up to the podium. If you could be in the middle, that would be great. If you'd be in the middle, and then I'm going to have, great, Mr. Hill on one side and Mr. Hirsch on the other. And before Ms. Smith starts, I just need to know to whom I should direct legal questions. I may have questions for you, Dr. Clarke. I'll just say Dr. Clarke and you'll answer. But am I asking Mr. Hirsch or Mr. Hill?
Advisor of her rights. I think I've been on the case longer. If I would say me unless Dr. Clarke or Mr. Hill.
Let's do it this way. When Ms. Smith has a question that is lawyer related or I do, we'll start with Mr. Hirsch. You should chime in, Mr. Hill, at any point. I'm not seeking to exclude you in any way, but it's going to be easier for the court reporter if both lawyers aren't answering at the same time. So does that work for you? More importantly, does that work for Dr. Clarke?
Yes.
Okay, that's how we'll do it. Thank you. Dr. Clarke, in just a moment, Ms. Smith is going to put you under oath, after which she will ask you questions involving your rights as a criminal defendant, certain things about the case. You need to answer her questions truthfully and completely. It is important that you let me or either of your lawyers know if at any point you have a question. If something's going not the way you thought, or someone uses a term that doesn't make sense to you, pause us so that it can be explained in a way that you understand. Will you do that?
Yes.
Great. Ms. Smith?
Yes, Judge,
And Your
thank
Honor,
you.
Hold on one second. Mr. Hill?
I'm actually gonna step back. I'm gonna let, right now, Mr. Hirsch handle this. If I need to, then
Yeah.
I'll let Mr. Hirsch.
Okay. You will stay in the courtroom. You're just not going to be at the podium. All right. So if Dr. Clarke wants to confer with you, she don't need to leave the room.
Correct.
You're right there. Okay. Works for me.
All right, before starting, Judge, this will be a misdemeanor plea with count 1, ag assault being reduced to simple assault. That's OCGA 16520.
And the other 2 counts were already misdemeanors.
Correct.
And it's a plea to all 3 counts.
Yes, Judge.
Understood?
Ms. Clarke, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Makiba Clarke.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
And is there any medication that you would normally take that you haven't been given today?
I take ashwagandha sometimes, but I didn't take it this morning, but that's a supplement. So no.
Okay. And the name of the medication matters less to these proceedings than
No.
what it helps with. What does that deal with?
It's a supplement and it helps with mood and stuff.
Okay. When you don't take that, does that leave you less able to understand what's going on around you?
No.
You don't feel woozy, confused, or out of sorts because you did not take the medicine?
No.
How old are you and how far have you gone in school?
I'm 44 and I reached the level of doctorate.
Are you at this time able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Okay.
In
What are
other
you
words,
asking?
let's say you wanted a jury trial,
Mhm.
you could obtain one of 2 ways. You could say, not guilty, I'd like a jury trial.
Okay.
Or if you didn't say anything at all, let's say you just not refused, but opted not to answer any questions, we would have a jury trial. Do you understand?
Silence would mean a not guilty
Okay.
plea. You also could say, I changed my mind, I'm pleading not guilty. That's basically ending our conversation. You go back and sit down and we bring the jurors in.
But with this, I'm not pleading guilty.
You're not, you're pleading nolo,
Nolo.
but you're not pleading not guilty, if that makes sense. This is where we get legalese.
Middle.
Yes.
Okay. That makes sense. to
And
me.
also, you don't want a jury trial. I think that's the import. You do not want a jury trial.
Do not
right?
want a jury trial.
Okay.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes.
Do you need more time to discuss your case with your attorney?
Will you give us more time?
You need it.
We do have 48 jurors waiting outside. If there was, let me put it this way, if there was a matter that you didn't cover with Mr. Hirsch or Mr. Hill that relates to the plea, then yes. If you would like to come back in a week, no.
If you're confused about the plea process, oh, wait, what is first offender? Or wait, if I went to trial, if I plead no contest or guilty, why am I giving up my presumption of innocence? If you have any of those questions about the plea colloquy, then please stop and ask. All right. So far, do you need any more time to discuss what has been discussed so far?
I heard you ask a question about the 3 charges and if I was putting in a plea for all 3. Is there a choice to put in a plea for 1 charge and?
So choice would probably be the wrong way to describe it.
Okay.
The state has made an offer, and that offer, it requires you to plead to all 3 charges.
Okay.
The significant step the state has taken, and only the state can do that, the court cannot,
Okay.
is they've reduced the 1 felony count to a misdemeanor. So your plea, should you go forward, is to 3 misdemeanors. That's legally very significant. No felonies in the mix. Your lawyers probably tried to convince the state to let you plead to fewer than 3 misdemeanors, but the state holds those cards. They could also say, you know what, we're going to dismiss count 3. And so Dr. Clarke only needs to plead to counts 1 and 2. But again, that's a district attorney
Okay.
prerogative, reducing charges or dismissing charges. They've reduced 1, so it's 3 misdemeanors. I did not hear Ms. Smith say that she's dismissing any charges. And so this would be a strange outcome, but you could say, I'm only going to plead to count 1. Okay, I could take your plea to that misdemeanor. Then we need to bring the jury in and have a trial on counts 2 and 3. But I've heard you say you don't want a trial on any count. So unless the state dismisses any counts, then you're pleading to every count. It just happens to be now all misdemeanors. And to reiterate, it's a nolo plea, not a guilty plea.
Okay.
Did I explain that in a way that you understand?
Yeah, you did.
Okay.
Let me throw in just deal the state is offering of reducing count one, the felony, to a misdemeanor is contingent upon you entering a plea to all three misdemeanors.
But the willful obstruction, is that reduced?
That's already a misdemeanor. There is a felony version of obstruction, but you're pleading to misdemeanor obstruction and we're charged with misdemeanor obstruction. Cruelty to children in the third degree is a misdemeanor, but they're not proceeding on that charge. Instead, you'll be charged with a lesser misdemeanor called disorderly conduct.
I didn't hear, is that correct? You didn't
That is
mention
correct,
that?
yes.
Okay. Thank you for clearing that up. So the state is reducing count one from felony aggravated assault to misdemeanor simple assault.
Okay.
Count two is unchanged. It was always a misdemeanor.
Okay.
Count three, they are changing count three, and you're pleading to a related offense, which is disorderly conduct. So a misdemeanor.
Okay.
So pleading to three counts, not changing the number of counts, but certainly reducing one from felony to misdemeanor.
Okay.
And I didn't know there was that other moving part,
Yeah,
but
totally.
it's okay. Count three is being modified to be a plea to disorderly conduct, which is
OCGA 161139.
great. Thank you.
Yes, Your Honor. And before I proceed, to put on the record, the state is objecting to the defendant taking this plea under NOLO, Alford, either one of those.
Okay.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
Yes.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
I waive the reading of it, but I would like, since I haven't seen it, did you re-accuse it or are you just reducing it on the indictment, on the face of the indictment?
Reducing it on the face of the indictment. We didn't re-accuse it.
All right, but it's just going to say disorderly conduct. It's not going to be written out.
It won't have to be written out, and this is a copy of the indictment. We're actually going to electronically sign the original. Where it will show up is on the final disposition, a copy of which the doctor will get, and it will show the original charges in the first column. You're familiar with that, but it will be a plea, count one, to the reduced misdemeanor, simple assault, and that's why I needed to get the statutory number. Nothing different with count two. And then count three is going to say cruelty to children, but the plea is to disorderly conduct.
Right.
That's where it will be reflected.
But there won't be a body of disorderly conduct like a formal accusation.
No, sir.
We waive reading and we waive any, yes, we waive reading if that was the question.
Ms. Clarke, do you remember being arrested on these charges?
On December 20th?
Yes.
Yes.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No.
No.
Do you understand that this is a non-negotiated or a blind plea and that the state will recommend a sentence to the court?
Recommend a sentence?
They're recommending a sentence other than what we're recommending.
This is the non-negotiated
Okay.
part. Ms. Smith, at some point during our conversation, is going to advocate for a sentence that I've been told involves some time in custody. Mr. Hirsch will be given an opportunity to advocate on your behalf for a different sentence. And as we talked about earlier, if the sentence I finally impose, because I'm not bound by either of the recommendations, I'm informed by them, but not bound by them. If the sentence I impose is more severe in any way from the parameters of what Mr. Hirsch advocated for, you'll have a chance to talk with him and come back to me and say, I'll take it, or no, thank you.
Okay.
But if it follows what Mr. Hirsch asked for or is in some respect less severe, you're bound by the plea that we're taking.
Okay.
All right. Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
I understand.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
So again, it's a little confusing. You are seeking to plead nolo, and is Dr. Clarke seeking first offender status as well?
Yes.
Okay, if I end up agreeing with first offender status and nolo, then it actually, there's nothing permanent about that. You can have it expunged, sealed, et cetera. First of all, it's a misdemeanor, which is harder for people to find who have access to, who have legitimate access, an employer, if you're going back to school to get an even more advanced degree or something. But with the NOLO part is a little less fundamental to what I'm saying right now. But with first offender, that's not a conviction at all. You would leave here today with no conviction. You would, if I sentence you to probation, have some probation, but it's not a conviction. And as long as you successfully navigated your sentence, which it sounds like you'll have no trouble doing, then it remains never a conviction. Your records can be sealed and then it can be expunged at the end of the completion of the probation.
Okay.
So it's conditioned on you maintaining good behavior during the time you're on probation. But that's the way first offender works, is that it keeps it from being a conviction up front. And then it's permanently not a conviction and expungable if you get through probation with no significant hiccups.
And you would have to agree to that. You would have to,
I would have to agree to sentence you as a first offender.
Okay.
If I agree to that, I don't get in the way of it afterwards, unless, making this up, 3 months from now, there's a domestic dispute, you get arrested for something. That new arrest would be a basis for me to say, gosh, Dr. Clarke, I misunderstood who you were. And first offender, you were entitled to, but you forfeited it because here we are 6 months later, domestic violence arrest. I misunderstood who you were. I'm going to take away your first offender status. So I have the ability to take it away, but it has to be predicated on a proven violation, not just on a whim. But we'd have a hearing, you'd have a lawyers for that hearing with a jury, and we'd talk about whether you did in fact violate your probation. But if you sail through probation, once you've got first offender, it's yours to keep and only to lose if you fundamentally misstep while you're on probation.
okay,
Okay? So you'll know when we're done if I've granted for first offender.
okay.
Ms. Clarke, are you a United States citizen?
Yes,
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
yes,
Have you ever pleaded guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
no,
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
no.
Has your lawyer explained what the First Offender Act is to you?
To the best of his abilities, yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment?
Yes,
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
yes.
Do you understand that by pleading guilty, you're giving up the following rights?
I'm gonna pause for 1 second. I want you to understand every time Ms. Smith is saying by pleading guilty, she's not trying to get you to suddenly slip up and say, oh, I said yes to that, so it's pleading guilty. That's shorthand for by going forward with the plea.
Okay.
Her standard colloquy, conversation with someone pleading, whether it's NOLO, first offender, plead guilty, whatever it is, to say by pleading guilty. That's not transitioning your effort to plead NOLO and get first offender by you answering her questions. You'll know at the end of our conversation, am I going forward with first offender? Am I accepting this as NOLO? So don't feel discomfort when Ms. Smith says, by pleading guilty, you are doing X, and say, but wait, I'm pleading NOLO. That's not changing anything.
Okay.
Okay,
Thank you.
Ms. Smith?
Yes. Do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes,
Counsel, are you satisfied that your client understands that these are the rights that they'll be these are the rights that they'll be waiving by entering this guilty plea?
Yes.
Ms. Clarke, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
no,
As to indictment number 25 SC 007534, how do you plead to count 1, the reduced charge of simple assault, count 2, willful obstruction of law enforcement officers, and count 3, disorderly conduct.
No contest.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
She keeps saying
Yes,
guilty,
yes.
but the question, let me ask the question differently, so it's less, so it's,
Less alarming.
yeah. Is this NOLO plea that you've entered, given with knowledge of the consequences, waiving your rights freely and the consequences of entering the plea?
Yes, so I agree.
Do you understand that you do not have a right to appeal directly from your guilty plea conviction? But if you believe that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Okay.
Do you understand that that process must be completed within 30 days from today?
Yes.
Do you also understand that you have 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Thank you, Ms. Clarke. Your Honor, if this case were to proceed to trial, the facts would show that on December 20th, 2024, officers of the Atlanta Police Department responded to 2369 Hamilton Road, Southwest Atlanta, Georgia, 30311. That's also in Fulton County. When the officers got there, they encountered someone laying on the floor. That lady was identified as Tiffany Perkins, the victim in this case. What they arrived to was an animal clinic. Outside the animal clinic was the victim. The responding officers then proceeded to go inside after they checked on the victim to make sure she was okay. When they went inside, the officers encountered Ms. Clarke, and she greeted them. She said, "Hey, how are you doing? What's going on?" And the officers then told her that there were claims from the lady laying outside, who was later identified as the victim, that she had been hit in the head with an object by the vet. So the officer started to ask Ms. Clarke, who was she talking to? Who was she talking about? And what is this assault that she's mentioning? So Dr. Clarke mentioned that she did not assault the victim, that they got into a verbal altercation.
And we're talking about Miss Perkins.
Yes.
Okay.
Yes, the victim is Ms. Perkins. So Ms. Clarke stated that she got into a verbal altercation with Ms. Perkins. Ms. Perkins is a customer. She brought her dog to the clinic. From my understanding, that was the second time she came. She came a week prior, and her dog contracted an infection. Ms. Perkins came back to get further treatment for the dog, and there was a disagreement about how the dog contracted this infection between the staff, Ms. Clarke, and the victim in this case. So that turned into a verbal altercation. At this time, Ms. Perkins proceeded to go outside of the door, and Ms. Clarke was telling her to leave, to leave, to leave. So Ms. Perkins begins to leave out of the door, and through video footage that the state will show today, Ms. Clarke has a dog noose in her hand that is an object used by a vet to capture or like catch a dog. So with that object, Ms. Clarke strikes the victim, Ms. Perkins, around 5 to 6 times. One time as she's facing Ms. Clarke, and the other times as the victim, in this case, Ms. Perkins, is walking out of the door. However, back to that investigation I was mentioning, so the officers came in to speak with Ms. Clarke and asked her about what happened. Initially, Ms. Clarke stated that she did not touch Ms. Perkins. She did not hit Ms. Perkins, and Ms. Perkins simply was walking out of the door and fell. The officers then asked her, did she have, she had cameras, obviously, so they asked were the cameras working, and Ms. Clarke said that there were dummy cameras, so they did not work. There was nothing that could be captured so she can show the officers. Through the investigation, the officer then went back outside, talked to Ms. Perkins and said, "Hey, who was the person that hit you with the dog noose?" And she identified Ms. Clarke. The officers then went back inside and told Ms. Clarke that they needed her identification because at this point, the victim had identified her as the person who hit her with the dog noose. At that time, Ms. Clarke responded by going into her office and closing the door and locking it. The officers asked for her to come out and to cooperate with them because they needed her identification to ID her. She eventually comes back out of the office and she tells the officers her name and her date of birth. At that time, the officers told her that she was going to be detained for assaulting Ms. Perkins. When they told Ms. Clarke that she was being detained for the assault, Ms. Clarke went into her office and tried to shut the door. At this time, Officer Jonathan Watson, who is the primary officer in this case, engaged in a tuggle with the door. He's trying to open it to get her to come out so she can be detained, and she's inside of the office, closing the door, pushing it to try to lock it again. She stays in the office around 8 to 9 minutes while the officers are trying to encourage her to come out of the door. There's a staff member that comes between the officers, the office door, and Ms. Clarke, and persuades her to come out after they like put a phone under the door and she talks to someone that tells her to come out of the office. She comes out of the office and the officers are able to detain her after a couple of minutes, and they take her to the police car. Throughout that night, they were on the scene for a couple of hours. Miss Perkins, she was outside, but she was transported to Grady Hospital. They did come and pick her up. At that time, the officers did more of an investigation, and initially 2 of her employees were also detained because the video that Miss Perkins gave to the officers showed that those employees were trying to escort her out while simultaneously Ms. Clarke was hitting her with the dog noose. So those are kind of the facts of the case. Ms. Perkins did go to Grady Hospital where she was treated. Ms. Clarke was arrested for aggravated assault and the other charges we have in front of us. And I did get a chance to speak with Ms. Perkins, and at first, of course, we were prepping for trial. She wanted to give a statement in this case. I talked with Ms. Perkins about the reduction that we have in this case and kind of how it mirrors the same kind of offer we was given as a felony charge because of the first offender. However, as understood, Ms. Perkins, she did not like the reduction. She's not happy about the reduction, and she has asked to not be a part of the Zoom or give a victim impact statement. However, she did previously give a statement to Ms. Shirley, the victim advocate in this case. So Ms. Shirley will give the victim's impact statement at this time.
Okay, before we do that, a couple questions for you. And then there was in the waiting room, this Zoom is set up a little bit differently because we weren't with jury selection, we don't use it the same way. But there was a TP in the waiting room. I tried to admit that person, not here. There was an iPhone on, so I don't know if that is Ms. Perkins, but you are saying, well, she's free to observe. She doesn't want to say something directly. She'll say it through the victim advocate.
Yeah, she did tell me that she was in the waiting room, but she wasn't admitted yet, but she said would not like to speak.
Got it.
And that statement can come through the victim advocate.
Got it. Well,
Your Honor, I would speak. I don't mind speaking.
She'll speak.
is that Ms. Perkins?
It is.
Okay. Ms. Perkins, if you could turn your camera on, please. Well, while you figure that out, once your camera's on, I'm happy to hear from you. I wanted to follow up on one thing I thought I heard you say, Ms. Smith, which is that according to what the police reported or is on body cam, Dr. Clarke says, oh, those cameras in the building, those are dummy cameras. You're not going to get any footage.
Correct.
It's my understanding from pretrial conferences with you and Mr. Hirsch that in fact they weren't dummy cameras and there was footage, and Mr. Hirsch disclosed it once he got it, but that would have not been an accurate statement to law enforcement.
That is correct.
Okay. All right.
While Ms. Perkins is getting teed up, there is a video that the state would like to show to the court at this time.
Okay.
1 second, let me share my screen. One second. This is camera footage from inside of the clinic that was recorded by the cameras that were inside. And this shows some of the altercation that I'll play for the court.
So before you play,
I'm
oh,
pausing.
it's going. Okay. So Dr. Clarke is in all black holding the pole.
That's correct.
The person in red is a
Employee.
staffer.
Yes.
And then it looks like another staffer further to the right with like white sleeves underneath scrubs.
Correct.
And then is that Ms. Perkins with the black vest?
That's Ms. Perkins with the like green jacket on, but yes.
Okay, great. Looks like she's holding
Yes,
Pop-Tart, something. Okay,
that's her.
okay.
That's one video, Judge. The state does have another video that I will attempt to share at this point. If it doesn't work, then we can move on, but 1 second.
While you're looking for that, I suspect I'm going to hear from Mr. Hirsch that Dr. Clarke has no criminal history. Is that what we don't have pretrial on here. You have any reason to contest that?
No, Judge.
Okay.
I'm going to share and hopefully the sound works because we do have sound on this one.
And is this also surveillance footage or would this be Ms. Perkins's cell phone? Because you could see it appeared on the video, she was filming as well.
Yes, that's the recording from her cell phone.
Okay.
Okay, those are all of the videos from the state, Judge. I'll stop sharing at this moment. But just to add for the record, that is why the state is asking for this plea not to be taken under NOLO or effort. But that's all from the state at this moment, and I'll let Ms. Perkins speak as she would like.
All right. Ms. Perkins, I am happy to hear from the victim advocate, and she can relay your written statement, or if you're able to get your camera and audio on, I'm happy to hear from you. Either one works for me.
Yes, Your Honor. I would like for the victim advocate to go ahead and read my statement. I did provide that statement to her. I feel more comfortable doing that through her.
100%. Understand that, and that's what we'll do. Thank you.
Thank you.
Good morning. If you could get near a microphone, that would be great.
Good morning, Your Honor. I'm submitting this statement to explain the full impact this assault has had on my life and my family. On the day of the incident, I was assaulted with a metal dog catch pole. This was not a minor or accidental event. It was a violent and terrifying attack. Being struck and restrained with an instrument designed to control animals was not only physically painful, but deeply humiliating and dehumanizing. In that moment, I feared for my safety and well-being in a way I have never been before. Since the assault, I have continued to suffer from ongoing physical symptoms, experience frequent and severe migraines, double vision, cognitive issues, fatigue, and pain that disrupt my daily life. These are not ordinary headaches or symptoms. They can be debilitating, forcing me to lie down in dark, quiet environments and making it impossible to function. The unpredictability of these migraines has made it difficult to plan even the most basic parts of my life. The emotional and psychological toll has been just as significant. I live with anxiety, stress, and lingering trauma from the attack. I often feel unsafe and on edge, especially in situations that remind me of what happened. My sense of trust has been deeply affected. What makes this even more difficult is that the person who assaulted me is a veterinarian, someone in a position that is supposed to represent care, professionalism, and trust. That betrayal has intensified the emotional harm and made it even harder to process. This incident has also had a serious impact on my ability to work. Because of the migraines, ongoing medical care, and emotional stress, I have missed work and struggled to maintain the level of performance I once had. There are days when I simply cannot function due to pain or exhaustion. I worry about the long-term impact this will have on my career and future. The financial burden has been overwhelming. I have incurred medical expenses for doctor visits, treatments, medication, and ongoing care. In addition, the loss of income from missed work has created significant stress. I am continuing to pay financially for something that was done to me, and the strain is going on. This assault has also had a profound effect on my teenage daughter, who witnessed the attack. No child should have to see their parent being struck in such a violent and frightening way. Since the incident, she has experienced emotional distress, fear, and anxiety. She has struggled with what she saw and has affected her sense of safety and security. As a parent, it is incredibly painful to know that not only was I harmed, but that my child now carried trauma from witnessing it. I worry about the lasting impact this will have on her emotional well-being and development. This assault has changed my life and my family's life in ways that are ongoing. My physical health has been compromised, my emotional well-being has been shaken, my stability has been affected, and my child has been harmed by what she witnessed. I want the court to understand that this was not an isolated moment. It has had lasting consequences that extend beyond into my family. I am doing my best to recover and support my daughter, but the impact of the attack remains with us every day. I thank you for taking a moment to hear my concerns and hope that you would consider my statement.
Thank you. And Ms. Perkins, I'm definitely considering your statement. I appreciate you taking the time to author that and to get it to the district attorney's office. And I think everyone in here hopes that you and your daughter are doing as well as can be, despite the fact that you have continued struggles as a result of what happened that night. But thank you for being online and for providing that statement. Ms. Smith, anything else?
Yes, Judge, I'd like to put the offer on the record.
Yes.
In this case, the state is asking for count 1, 12 months to serve, count 2, 12 months probation, and count 3, 12 months probation, for a total of 36 months to serve 12 months with the balance probated. Regarding the special conditions of probation, the state is asking for the defendant to complete an anger management course, 60 hours of community service, to have no contact with the victim, and to write an apology letter to the victim. That is all from the state.
All right. So the one exception to the no contact would be to get the letter, but the letter would, I assume, go from Dr. Clarke's counsel to you, and then your office would get it to Ms. Perkins.
Yes, Judge.
Okay. All right. Thank you. Mr. Hirsch.
Thank you, Your Honor. My client is 44 years of age. She started out at community college and went to Tuskegee, eventually went to Tuskegee. She has a bachelor's of science, and she also has a PhD, no, a doctorate. A doctorate from there, allowing her to be licensing her to be a veterinarian, which she has been for well over 10 years. Actually, one of her degrees was in bioethics. She started the clinic where she is now, where this took place in 2019. It's in a low-income area, and she at times has to deal with some difficulties around that. She employs 8 employees because of the area she's in and what she does. She started a nonprofit in 2021, Vettoria, like Victoria, but V-E-T, community.
Victorious community.
Victorious community. Okay. She also regularly volunteers at Love for Animals and other community service nonprofits that assist animals. Your Honor, on this day, it actually had started a few weeks before. Ms. Perkins had brought her dog in, and I think the dog had been bitten, and Ms. Perkins came back 2 or 3 weeks later, which is December 20th of 2024. The dog ended up having parvo, was the diagnosis, and I believe Ms. Perkins wouldn't pay the bill and was upset, wanted to know if the parvo was given to her dog at the clinic 2 weeks earlier. In any event, there's this altercation. She refuses to pay, which is fine. Eventually, the staff and Dr. Clarke just want her to leave. About 30 minutes prior to what you saw in the video, my client calls 911 and asks for the police to come to remove her. Ms. Perkins continues to be boisterous. She won't leave. She's being abusive with the staff. Finally, Dr. Clarke comes back out and is like, you need to go. And although there's no audio on the internal video, and there is none, it's not that there is none.
Like the body cam.
Right, exactly. I had thought there was at one time, but there isn't any. So you can see the body positions of folks that Ms. Perkins goes to leave, finally is listening. Dr. Clarke is hanging back. I mean, she's 15 feet away. She wants to de-escalate the situation. She just wants to protect her business. She wants to conduct business, and she wants to do a C-section on a dog because that was scheduled, and it was late. It was at nighttime, and she needed everyone out so if they could do the surgery. Unfortunately, this was so much on her mind as evidence of because she was arrested, she couldn't do the surgery, and unfortunately, the dog passed away. In terms of the incident itself, and some of the things that may have seemed like she wasn't cooperating with the police, she does say she has some difficulties with the cameras. These are the first time she had to retrieve any information from the cameras. So it's true, she says they are dummy cameras, and then they asked her again about the cameras, and she said, and this is from the police report, quote, "The cameras do work, I just don't have access to them right now." And as a matter of fact, when she first came into my office, I've been on the case since the beginning, I asked her about these videos, and I think it took about 6 months to get the videos. People from the security office had to go down and download them. And there's some skips in the videos, which doesn't affect the scene itself. After the incident, my client called the police as well. So in terms of Ms. Perkins, I don't know how much of this would come out at trial. She does have at least one prior domestic violence arrest. It concluded in 2022, but there was a letter from her sister talking about how Ms. Perkins is the aggressor and bullied in that incident, and that there were repeated incidents. Again, I don't know if that would come in for habit or not, but that was from her sister in a court file. But in any event, the question now is, under 16.324, I think at trial, is how much is too much? 16.324 is defense of property, talks about stopping a criminal trespass or other tortious interference. You can only use deadly force or force used to cause substantial bodily harm. if the person is likely to commit a forcible felony, I believe. In this situation, we certainly have a criminal trespass. She's told repeatedly to leave. She actually does leave and then walks back in. Then she leaves again and looks like she's going to come back in. And Dr. Clarke is just like, okay, enough is enough. When she told the police she didn't hit Tiffany Perkins, that's what she believes. That's what she believes. I mean, she wants like a close-up of the video because she doesn't recall hitting her with the pole. In terms of the pole, I have one that Dr. Clarke brought me. The loop part that goes over the neck is actually fairly soft, and then the pole itself is aluminum. Ms. Perkins goes to the hospital thereafter. I think she had told the police that of course, she has a civil suit going on, which I think would come out at trial and could affect one's bias. I believe she told the police that she lost consciousness. She was in and out of consciousness. But what she says on page 13 of the medical records, or at least what the medical records say, is that she reports being struck several times on the head, has a significant headache now. She did not lose consciousness or fall. She wasn't struck anywhere else other than the head. In addition, Your Honor, in terms of the headaches and migraines and double vision and dizziness, you know, we feel terrible that Ms. Perkins is going through that. I can tell you, though, from reading the transcript in the civil case from April 8th of 2026, she said the same things, and she attributed the headaches and migraines and dizziness and double vision to this incident. And then she was confronted with that she had been to a neurology group a month before, and under history of illness, her chief complaint was double vision, and that she had had 2 years of lightheadedness and being off balance, as well as visual blurring. And in addition, she applied for, and unfortunately, she suffers from anxiety and depression. And I hope she's dealing with that well. We hope she's dealing with that well. Dr. Clarke does as well. But because it was brought up in the civil case transcript on page 67, the question was, your anxiety and depression had previously been significant enough that she had applied for Social Security disability benefits, again, prior to the incident. So whatever she's going through, we hope that she is a speedy recovery. In terms of course, causation, that's why I bring that up to the extent the court was considering it. You know, she also, I think, talks about being concussed. I don't know if she said that here, but that was in the transcript, and there's no diagnosis of a concussion right at Grady. Given that, Your Honor, I think what a jury would believe in this case is that Dr. Clarke had every right to defend herself. She did everything right. She's standing back up until perhaps she goes to the door, and at which time, did she use more force than was necessary? Perhaps, or the answer may be yes, but of course that's not the legal question. Regardless of what the jury decided, you know, she's now being judged, I suppose, in her worst moment in a situation that she tried to avoid by calling the police, by just even having the stick and standing back. And if you notice in the video, the first time that Ms. Perkins, I think she comes back in, and Dr. Clarke is just holding it, the stick out like a broom. Dr. Clarke, there's some conversation about Ms. Perkins being a victim of domestic violence, and that had been brought up, and Dr. Clarke said that some staff noticed some blood in her mouth. Of course, my client is a doctor. She's also worried about communicable diseases. She doesn't know how this person's going to act, so she's understandably trying to put some length between herself and Ms. Perkins. Once the incident happens, it happens. You know, I don't really have too much to say about it other than there's a reason police officers get detailed training to learn how to control their adrenaline so that they don't overreact. And I think that this is a fair resolution. I think that if we went to trial, I think on a law school essay, she probably gets simple assault. I think a jury may acquit her altogether, but they may not. And she has a lot to lose. She has 8 employees at this clinic. So we're asking you to accept the no contest plea under first offender. I think it is a good result. I understand that Ms. Perkins isn't happy, but luckily for Ms. Perkins and good for Ms. Perkins, she can avail herself also of a civil resolution. That may not make her whole in Ms. Perkins' mind, but it's better than not being able to do that. So of course, my client has a lawyer for that as well through the insurance company. She's been kicked off her insurance because of this. And she also has a lawyer to make sure to comply with and make sure that her license is intact. I don't think my client does not fear and would like a trial on the merits if it was, but of course, not if she could possibly be convicted of a felony. And so she'll have to get to the truth of the matter in a litigation sense, I believe more so in the civil case, and she'll have that opportunity. When I say she wanted that, I don't want to mislead the jury. She wants to enter this plea. She wants to avail herself of this plea if she can continue on with her clinic and, of course, not go to jail. So we would ask you to follow the state's recommendation with the exception of any custodial time. I think that given what had happened, regardless of what one thinks of the use of force, I can certainly put myself in Dr. Clarke's shoes and see where she was coming from. She's 44, never been in trouble with the law. She is otherwise not only stable, but offers social services involving her profession to low-income folks through her nonprofit. So we would ask you to impose a sentence of 36 months, all the other terms and conditions of probation, with any other terms and conditions that the state has asked for or the court sees fit.
All right. Dr. Clarke, you have the right to be heard as well, just like Ms. Perkins, through the Victim Witness Advocate, is afforded an opportunity to talk about how this has impacted her. You're free to say anything. You don't have to say anything at all. It's not an obligation. And Mr. Hirsch has been very thorough, but if there's something you want to add, I'm happy to hear that. Not so much on, let me tell you what really happened. I saw some video and we're not doing the trial anyway. So it doesn't need to be a he said, she said. That being said, this is your plea in sentencing and not anyone else's, which is why you have this, we call it the right of allocution, if there's something that you do want to say.
Okay. Hi, Your Honor. Thank you for allowing me to speak. My name is Makiba Clarke. I'm originally from Boston, Massachusetts. I started at Roxbury Community College and then decided to be a vet after the age of 22. Went to Tuskegee University, got my bachelor's in biology and my minor in ethics, coincidentally. And then I went to vet school, got it my first time, and I have my doctorate in veterinary medicine. I've worked in corporate medicine. I've worked in emergency medicine in McDonough. I've worked in a nonprofit space in Miami, Florida. I got the opportunity to buy this clinic in 2019. And I'm an independent vet clinic, which is less than 20% of clinics in all of the United States. I have helped over 13,000 pets in my 7 years here, and I've had over 10,000 clients, and I have not gotten to altercations with any of them. When I look back at my records since 2019, I've had to call the police 15 times at the clinic. I've had guns pulled on me at the clinic. I have had things happen at the clinic that would perhaps make me more on edge. I grabbed the rabies safety device as a protection. I am a surgeon. I had a dog on the table to go do a C-section. I don't want to be harmed either. In the moment, I didn't want my staff to be injured and I didn't want to be injured. But I do have regrets about grabbing the rabies safety device. But I am glad that my staff and I are safe and I'm able to stand here before you and tell you that I would like you to look at all the facts and understand that I want justice, but I also want somebody to hear me. I was arrested within 5 minutes of the police showing up. After calling them 45 minutes before, I called them before the rabies poll incident. I called them after twice. And now I have had to get security. I got a security guard as of January 2025. I also have gotten kicked off of my insurance. I now pay 4 times the rates. And Max was correct in his assessment in that I didn't believe I had actually struck her with the pole. And I was surprised when the police said that. And thank you for letting me
Welcome.
speak.
I appreciate hearing from you. So let me march through a few procedural things, and then we will. Did you have anything you wanted to add? No, you were getting into that posture.
And the court mentioned, and this really goes to her statement, is the video that Ms. Perkins has is what it is, what she could take. Our case looks much better when they just have Ms. Perkins' video. Dr. Clarke is like, I have nothing to hide. Give them our video too. If the incident is what it is, I have nothing to hide. I want everyone to see it. So this was an unusual circumstance, I think, where the best video for the state is one that the defense readily turned over.
I don't know about readily, but did turn over from the dummy cameras. First, Dr. Clarke, I find there's a factual basis for your plea, meaning had this gone to trial, a jury could find you guilty of these 3 misdemeanors. Would they? I don't know. I don't disagree with Mr. Hirsch that there's some good defenses here, but those videos are powerful. I will note that from Ms. Perkins's video, there's clearly some back and forth, and then she cries out as if in pain. I suspect that's when there was contact, intended or not, but I think the state could very much point to that as a point when there was contact that was made. But I don't need to decide that because you're entering your plea. I do need to be comfortable that there is some evidence that a jury could point to if they were going to find you guilty of the crimes to which you're pleading, which are the 3 misdemeanors. And frankly, and I trust Mr. Hirsch told you this, with simple assault, you don't have to make contact with someone. Come and ask someone with this rabies poll, whatever you call it, is enough for an assault. And that's what I'd be telling the jury, and they'd be processing it. And Ms. Smith would say repeatedly in her closing argument, she did hit her, but you don't have to find that she hit her. Assault doesn't require that. It requires the apprehension of unwanted contact. And I think what to me was most poignant about what Ms. Perkins shared, beyond the length of the discomfort and suffering she and her daughter have had, was that word humiliating. You grabbed what you could grab, but you came after her with an animal control tool. And I've got to think that someone who, in her mind, had a legitimate grievance. My dog was infected with parvo, and I think it happened at your clinic. She may be entirely wrong, but if that's her mindset, then she sees the medical professional who she might be holding responsible coming after her with an animal control tool. And I'm sure that's not what you were thinking. You got what you got that would keep a distance for the reasons that Mr. Hirsch explained and maybe keep you and your staff safe. But it resonated with me, and so I understand why this is something that sticks with Ms. Perkins. So I do find there's a factual basis. I also find that your plea is knowing, meaning you've understood what we talked about. And when you didn't, you stopped us and said, what do you mean? Wait, you keep saying plead guilty. I'm not pleading guilty. And we worked through that. And your plea is voluntary, meaning no one is forcing you to enter this plea. You're not enthusiastic about it, but after consulting with both Attorney Hill and Attorney Hirsch, you've decided that it's in your best interest to resolve the case this way rather than run the risk of going to trial and have a jury come back with a guilty, not on simple assault, but aggravated assault. So I will accept your plea. Mr. Hirsch, is it all right if someone in my office signs your name to the indictment indicating Dr. Clarke's plea in this case?
Yes, it is certainly all right if they sign my name to a plea of nolo contendere.
We'll get to that in a minute.
Yes, okay.
Assuming we're going forward, signing your name on it is okay.
Yes.
Okay. And Ms. Smith, can we sign for you? And Dr. Clarke, can we electronically sign your name to the indictment as well, indicating your plea?
Yes.
All right, we'll do that. Dr. Clarke, you qualify for, and I think it's appropriate in this instance to be treated as a first offender. I've already talked to you a bit about the benefits. It's primarily benefits, but the risk if during your period of probation, you mess up, get in trouble, arrested for something, not only do you have those new charges, but this first offender can go away. It then becomes a misdemeanor conviction, and your ability to seal it and expunge it becomes less. The other thing I want to make sure you understand, I don't think it's a big risk for you, but I need to tell folks, you get one first offender. And there are people in life who don't want to use it on misdemeanors because life could get more complicated for them in the future, and they want to save it up for that inevitable felony situation. My hope and expectation is that you're not going to have another situation. But you should know that if for whatever reason you are arrested for and indicted for a felony 3 years from now, there's not also a felony first offender out there to use. There's one, and you're using it on misdemeanors. Do you understand that?
Mm-hmm. Yes.
Does that change your desire to be sentenced as a first offender?
No, it doesn't.
Okay, all right. I'm not a big fan of NOLO pleas for a bunch of reasons. This is a case that I think fits into that space, though, and so I will also accept this as a NOLO plea, not because I have doubts about the state's ability to prove the case, but more so because I think there is value for the community to protect your ongoing ability to serve the community in the way that you have and to maintain your professional licensure. It was an important factor that I weighed in this process, what you do for the community and the nature in which you do it. You could have joined VCA and charged $50 to clip my dog's nails, and that's not what you do. I suspect there are people who get treatment at your clinic who are able to give you $10 because that's all they have. But you are there to help take care of them and their loved ones, and you do that, and that is valuable. There are not enough veterinarians in the part of town where you operate, and I hope that you are able to continue to do that. That doesn't minimize what happened to Ms. Perkins. It doesn't minimize her ability to pursue recompense in the civil case. But I don't think we should, I don't think the district attorney's office is doing this, use the criminal system as a way to pry financial results out of people. This case as a standalone, just taking in all the facts and circumstances, I think this is a reasonable resolution. I don't see custody as an appropriate outcome given your background and where I see your future. And so while I understand the state's recommendation, I don't minimize in any way all the symptoms and repercussions that Ms. Perkins relayed to victim witness that were relayed to me. I'm going to sentence you to 12 months probation on each of the 3 counts and run them consecutive with each other for a total of 36 months probation. Special condition of probation number 1, the most important one, is that you have no contact with Ms. Perkins. You may have to interact with her because you're in court together on the civil side. That's as close as you get to her. Now, it has a flip side to it. She needs to not be coming to your clinic. I don't think she's going to do that given the outcome she had with her loved one. But no contact with Ms. Perkins. You'll need to complete 120 hours of community service. I used to be a fan of the apology letter, and then I once made that a requirement in a matter where the Supreme Court said forced speech is not good speech. It may be that you have some words that you want to share with Ms. Perkins that you will channel through Mr. Hirsch or Mr. Hill. You can't go directly to her, and they get that to the district attorney's office, but I'm not going to require it. In your mind and your heart of hearts, you may think the apology should be flowing in the other direction. I'm not taking sides on that, but I'm also not going to compel text that might not be sincere. But you do need to have no contact with Ms. Perkins. She's going to recover and regroup in the way she's best able, and that will be without you giving your thoughts about what happened on December 20th, 2024. I will set a behavioral incentive date of June 3rd of 2028. That means that if after 24 months of probation, you've knocked out the community service, there's been no reports from Ms. Perkins about getting emails or texts from you, or you getting online, even if you don't directly communicate it, but you post, stay away from this lady. She's nothing but trouble. Let me finish, and then you can ask questions. That's talking about the case in a public way that is directing speech in her way as well. And so you're going to want to talk to your lawyers about how you might do that if you think that's necessary. But I do think that a behavioral incentive date makes sense in this matter. I will need you, Mr. Hirsch, to fill out a form, and Ms. Nelson will get it to you, although it may be in one of the piles of forms we've got, that is just a bunch of contact information for you, because the entity that does misdemeanor probation needs to reach out to you to get that process started. So there's a form that needs to be filled out, and then they contact you, and you engage with them, and connect with them in whatever way you agree with them. You had a question.
And I have the same rights that she's not to contact me, write anything on social media, on Google, or anything.
So Ms. Perkins is not the defendant in this case, and I'm not in a position to limit what she does. You may decide, and you should talk to Mr. Hill or Mr. Hirsch about this, that you need to take some steps to keep Ms. Perkins away from you, and there are ways to do that. You may decide that in connection with the civil litigation, there's certain claims that you need to press to protect you and your professional litigation. I can't give you legal advice, but there are steps that anyone can take if they feel that there are libelous things happening, defamatory things that are happening. But my ability to constrain behavior is limited to you as the person who's entering a plea here today. And so the only restrictions I'm setting are that you don't have contact with Ms. Perkins, and you don't say things on social media about this situation, because that's about Ms. Perkins. And if that gets into a gray area for you, talk with one of your lawyers, and they'll give you counsel on that. But this is a situation where for you, you're moving forward on the criminal side and beyond it. And that involves you not engaging with Ms. Perkins outside the very, very narrow confines of that civil litigation, where you have a lawyer who's going to be able to make sure that it's all mediated, not in the sense that you go to mediation, but that there are other people around insofar as you're in the same space with Ms. Perkins. Does that make sense?
Yes.
Okay. Mr. Hirsch, any questions about any of that?
No, Your Honor, we appreciate, as always, your consideration and thoughtfulness. Thank you.
Did you get the form that needs to be filled
Yes.
out? Great. You all should fill that out. Ms. Smith, anything else on behalf of the state? I appreciate your preparation, Ms. Davis, being here to aid you through jury selection if we had that, but we won't. And I think that's it. So you all should be on your way.
After we give this form to the deputy, is that right? May we be excused?
Yes.
And Judge, I think it's something that wasn't mentioned. I would like to ask for an order restricting this from her criminal history while she's on first been a probation.
Yes, what you need to do is submit a proposed order in Word format, copy Ms. Smith on that email to Ms. Nelson, who is my litigation manager. And if you get me that proposed order, I might tweak it a little bit, but that's an appropriate order, and I'm happy to enter it when I get it from you.
I need to write Daryl's number here.
Yeah.
I need to get it from myself.
Go ahead.
Okay.
Yes, they should come on in once these folks head on out.
Oops, sorry. Thank you. Is Daryl's the only one here? Daryl's the only one here, but I know my sister's living.
Thank you. Dr. Clarke, you've got good handwriting for a doctor. That's impressive.
Thank you.